Welcome to the August 13th, 2024, 6:30 p.m. City Council meeting. We do have a quorum, so I'll call this meeting to order. Would you please join me in a moment of silence? And the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. City Clerk, would you please read the rules to speak?
Yes, sir. Individuals wishing to speak on agenda items must complete a sign-up card prior to the item being introduced. Those wishing to speak on quasi-judicial public hearings must complete a sign-up card and sign the oath. Sign-up and oath cards are available on the table. Individuals wishing to speak on non-agenda items may do so under petitions from the public present. This opportunity is offered twice in the meeting, and individuals may speak at either the first or second petitions, but not both. No sign-up card is required. Citizens shall not comment on any issue more than once during the meeting. All comments except petitions and requests must address the pending issue, and citizens will be given 3 minutes to speak. Citizens wishing to speak on the consent agenda must submit a sign-up card identifying the items of interest. Each speaker shall be limited to 3 minutes to speak on the entire consent agenda. All sign-up cards and exhibits being submitted to City Council shall be placed in the box on the table.
Thank you very much. Council, can I get approval of the minutes from the regular City Council meeting on July 23rd, 2024, 5:30 p.m. meeting?
So moved. Second.
I have a motion and a second. All those in favor say yes. Yes. Opposed? Minutes approved. City Attorney?
Windows sign in dialogue
Good evening,
6
Mayor-
ratio
Mayor
3
Council.
Tuesday, August 13.
Point of business I'd like to bring up at this point. At your previous council meeting, City Council had voted to continue the hearing on small-scale amendment number 3, 2022, which was Bristol. That included ordinances number 19, 2024, and 2024, and that was continued to tonight's council meeting. These items will be heard during the public hearing portion of the agenda. As part of that motion to continue, there was a portion that recognized that a certain number of speakers had spoken, and the persons who had not yet spoken but had submitted speaking cards, of course, would be carried over to tonight's meeting to speak, and that if they couldn't speak, they could have, individuals, of course, speak for them. To the extent that that motion restricted any speakers other than those who had already spoken from speaking tonight, I would advise that you rescind that portion of the motion, making it clear that the members of the public who have not already spoken on this agenda item are able to submit speaker cards tonight on this public hearing item.
Can I get a motion to that effect? Hold on, go ahead.
Mayor, can I be heard for a moment on that?
Again, yes.
Yes, sir. I think it's probably best practice to go ahead and allow any additional speaker cards that have submitted speaker cards to hear tonight. But I would like to lodge a standing objection to any of the speakers that are presenting commentary on new cards after I think it was 26 that were turned in that night, under the basis that the Section 2-26, Rule 5B of the city's Code of Ordinance specifically states that an individual wishing to speak on a quasi-judicial matter must complete an oath card with their signature and submit it to the city clerk prior to the start of the public hearing. This is a continuation of a hearing. But the city attorney and I have spoke about it, and I think the kind of resolution that we came to is that with a standing objection in place for the record, that, we think you should call the cards.
Mayor, I just
Clarification.
I just want to point out, since that ordinance was enacted, the law on public participation has developed. And I believe it's the intent of Chapter 286 to allow that participation. So in an abundance of caution, that's why I'd advise, we would open it up to anyone here tonight that didn't have a card if they submit a card to speak.
It sounds like you're saying, Attorney, that you're okay with that. You just want to have a standing objection to it.
Yes, sir. This specific city ordinance was passed on July 14th, 2020 by the city adopting these rules. And, but, like I said, if we have a standing objection to the later submitted cards, we'll proceed. We're just leery of the fact that this could get continued again, depending on how many additional cards come in. And it's a great expense and burden on my client, both financially and, frankly, they put their entire presentation and experts out there, and there's been 3 weeks for, the public to research and come up with additional arguments to add and bring in additional cards and speakers to do that. So we believe we're prejudiced by continuing, but.
Counsel, you hear the, both attorneys. Member Nelson?
I would make a motion to allow people who have not spoken before to go ahead and put a card in.
Second.
I have a motion and a second. Roll call vote.
Member Cole?
Yes.
Member Nelson?
Yes.
Mayor Diesel?
Yes.
Vice Mayor Robinson?
Yes.
Member Stokel?
Yes.
Passes unanimously. Got off track there. Now, my city manager.
Yeah, good evening, Mayor, Vice Mayor, and City Council. We are on item 6A, which Board of Adjustments and Appeals. The Board of Adjustments and Appeals semi-annual report is provided for City Council and the packet is written. No action is required. On to 6B, the Titusville Environmental Commission. Accept the resignation of regular member Jim Yount of the Titusville Environmental Commission. The resignation was effective on 26 July 2024.
Counsel, any comment? Member Stokel?
Yep. When I had my briefing, I will tell you, this one was personally sad for me to see. I still call him Mr. Yount, Doctor. He was my biology teacher at the college. And I don't know, staff, do we know how long he's been on this board?
20 years.
20 years. So this was very disheartening to see, and I would just like to say, I'm not sure exactly why he's resigning. I do plan to talk to him, but to lose somebody that's been serving for 20 years, and I'm not seeing any real, medical reason or anything. I just think we need to be very careful of who we're allowing on our boards, what the culture and climate is of our boards, that we're not losing good people that bring a lot of value to the boards and want to be here for the right reason. So this, again, is very sad to see.
Thank you, Member Stokel. Vice Mayor?
Yeah, that's my concern, because my notes say that I would like to know why. Yeah, I really would like to know why he is, because I thought he was a great asset to the board and to the GEC. And I would, if it's possible, any way possible, for us to just get a hint on why he is terminating his services, because I'm just concerned.
Do we have the option, I'm assuming he's not here tonight. Do we have the option to table this vote until we hear from him? City Attorney?
It's council's pleasure whether you want to table.
Member Stokel, you brought that up. Would you like to see that? Or, I mean, it doesn't look that difficult to do.
Yeah, I'm okay with either one. I have a feeling it says it was effective end of July, that even when I talk to him, that he won't be coming back. I just we don't get to talk about things outside of our meeting, and this just deeply concerns me. And I'm concerned about our boards. I want to make sure we have good people on there that are serving and doing what's right. He has been vested in this community for years and has a very, very much a passion for this. And for him to leave, it was just very concerning for me.
Well, I look
That's
forward to
telling me
hearing.
that there's other things that are going on.
Vice Mayor, you there?
Yes, I think that we, if we can, if it's our pleasure to table it, at least make an ask. At least make an ask on this, because that is very concerning to me.
Do we have any cards on this? I need a motion one way or the other to move forward or not. Member Nelson?
Move to table the resignation of Jim Yount of the TEC to
Second.
the next meeting.
I have a motion and a second. Roll call vote.
Member Nelson?
Yes.
Mayor Diesel?
Yes.
Vice Mayor Robinson?
Yes.
Stokel?
Yes.
Member Cole?
Yes.
And hopefully, if nothing else, this table shows him how much we value what he's given us and are concerned. So I'll leave it at that. Petitions and requests from the public. Can't say the same thing, no.
New meeting. Connie Milton, Wendover Farms. I passed out a little research that I did. This is researching ad valorem taxes. I looked at 5 different apartment complexes in the city of Titusville, and I looked at 2 different subdivisions within the city of Titusville. Kind of looking at, okay, how many acres are each one, and how much ad valorem taxes do we get? How much does the city of Titusville get for each one? Well, if you look at Summerhill Apartments, it's 55 acres, but only about 20 acres of it is built on. A lot of it's wetlands. Wendover Oaks is 19, so close to 20 acres. Solomere Grand, 20 acres. But now it's got a lot of buildings, 9 buildings, 20 buildings for Wendover Oaks, 12 for Timber Trace, 14 for Summerhill. But if you look at the column for ad valorem taxes on each one of these, well, you get about $179,000 for Timber Trace. You get $454,000 ad valorem taxes for Summerhill. But that's total ad valorem. That's not what the city of Titusville gets. The next column over is what the city of Titusville gets in ad valorem taxes. So if you look at Summerhill, they get $157,000 ad valorem taxes. You get another non-ad valorem of $28,000. That's for your stormwater and wastewater, okay? Now, if you look down here at the last 2 rows, that's subdivisions, R1B subdivision, 2 brand new ones in the city of Titusville. You got Country Club Estates, and I said, okay, let's take 80 homes there. You can get at least 80 homes on 20 acres. R1B allows a little more than 80 homes on 20 acres, but we'll just say 80 homes. Out of 80 homes in that subdivision, and also in Park Preserve subdivision, 80 homes there, you get, for ad valorem taxes, $408,000 for one, $285,000 for the other. But that's not what City of Titusville gets. City of Titusville gets $149,000 for Country Club Estates on 80 houses and $102,000 on Park Preserve for 80 houses. And then their non-ad valorem's about the same in the sub. So if you build something on 20 acres, whether it's single-family homes or it's an apartment complex, City of Titusville gets approximately the same amount of ad valorem taxes and non-ad valorem taxes as either development. So just thought I'd let you know. Thank you.
Thank you, Connie. Petition request. Yeah, come on up.
Good evening, Mayor Diesel.
Hi.
Mr. Vice Mayor, Madam Secretary, council members. As you know, this is my 3rd time appealing to you to please enforce your existing codes and laws about the excessively loud white F-150 truck in Gardendale. I am dumbfounded as to why you've allowed this to go on every morning since February, unless it is true, as the truck owner has boasted, that he is, quote, friends with the cops, unquote. This issue has disturbed myself and another neighbor most directly, even though you also have a petition from 16 others and a mechanic's statement attesting to the loud and modified exhaust system. Here are some more laws which I did not get to read last section. 316.272. Every motor vehicle shall at all times be equipped with an exhaust system in good working order and in constant operation, including muffler, manifold, tailpiping, to prevent excessive or unusual noise. 13-102, which is a Titusville code, is also noise related. And it basically states that all vehicles shall have, quote, all standard equipment, manufacturer's mufflers, and noise reduction equipment in use and in proper operating condition. Florida Statute 877.03 reads, quote, committing an act that disturbs the peace and quiet of others, starts a fight, or acts in such a way that breaches the peace is a violation. And again, your code 1303, section 14 says that noisy equipment between the hours of 7 p.m. to 7 a.m. shall not be in use which is attended by loud or unusual noise. I've done my share of volunteer work in Titusville and know for a fact that if a person causes a noise issue at the cold night shelter, they are removed from the premises immediately. I know for a fact that the airport in Titusville also routinely limits takeoff and landing noise during early hours.
Let me ask you a question. Have you talked to code enforcement?
Yeah, I have.
And
And-
what's your discussion?
They tell me to take it to court. I don't think I should have to take it to court when it's on the books. And
Okay.
I offered to loan the guy money to quiet the truck down, and he went like this, and within a minute, he told me he was friends with the cops.
All right, obviously, I'm not the guy to go out there and talk to the guy, but I will say that in my inquiry, and city manager, you can confirm or help me out here, but code enforcement has been out there, and they've even been out there in the morning when he started it up. And basically, their feeling is that it is within the numbers and that it's like a motorcycle, and then he goes to work. But I can only tell you that when you did speak, we didn't say, okay, too bad. We sent our code enforcement out there, and that's why I was wondering if perhaps you were able to talk to them.
Code enforcement was sent out a long time before I came to these meetings, and they took a decibel reading allegedly 50 feet away from the vehicle, as furthest away as they could get. When the law reads, they could actually take one right at the vehicle. And it's interesting to me that the code enforcement officer that allegedly took that reading, he no longer works for
Well,
the city.
I'm not going to get into all that.
Well,
I'm going
I
to tell
just
you
want
that
you to
code
know it.
enforcement has been out there, and it's not my understanding they've been out there recently, since you came to the meetings. And I would like for you to have an opportunity to speak with them, because that's basically what we've got back is that, whether it's too loud or when the train goes by, it's too loud. And like you said, the airplanes situation. In that case, obviously, I have empathy for you if it's too loud and we need code enforcement to do that. But they have been out there. We made sure they got out there. And their report is that it's within code and they can't do anything with him right now. So with that, if I were you, I'd call code enforcement and say, this is what I got at the council meeting. What can you tell me?
I will.
All right, thank you.
But I'd like to let you know I took a decibel reading myself, and it's not a quiet
Well,
truck.
there's something to take to code enforcement.
Thank you for your time.
Thank you.
See you next meeting.
Yep. Next up. How you doing?
I'm doing great. How are you doing?
Good.
I just wanted to remind council about concurrency because I know I spoke briefly on it a while back. But as our city grows and as we're looking to develop more and more of our city, I think something that we really need to keep in mind is the fact that concurrency is legislatively enacted growth management tool, and it's designed to ensure availability of public services to accommodate all development. Formation and implementation of the capital improvement plan for delivering the essential public services in a timely manner, linking approval of development to existing, current, or planned and funded future availability and of adequate public services. It's a legal foundation. And under our comp plan, we have a capital improvements program that's supposed to have a plan for meeting the level of service standards. That program is supposed to have a 5-year budget. And I think it's very important to understand that under Florida Statute 163.3180, developments that result in levels of service below our comp plan level of service are not allowed. The only exception is when there is a budget planned to be implemented to support the levels of service. In our concurrency objective 1.3, it says the city will evaluate the impact of development on level of service to facilities necessary to meet the level of service standards that are available concurrent with the impacts of the development. Policy 131, new development shall be in a manner that minimizes additional public investments. Policy 132, prior to approval of a building permit or functional equivalent, the city shall consult with a water supplier to determine adequate water supplies to serve the new development. Policy 133, Expansions of urban service areas shall be reflected in and coordinated in the city's capital improvement program. Given the de minimis amount listed as the utilities infrastructure line item in the budget and capital improvement plan, it appears that the unplanned for cost to the city for all of the developments we're building is a promise that we can't keep. And it's going to fall on the taxpayers to pay these bills. And I think it's unfair that the taxpayers are going to have to improve infrastructure as this city grows, as opposed to the city planning for the growth appropriately. The other point I wanted to make is that we as a city should be looking at how can we make sure that our workforce has an opportunity for real meaningful income and real meaningful workplace growth. And I think we should be looking to develop some kind of, a fabrication facility, like a chip plant, or some other fabrication opportunity in the high-tech realm for the space industry, so that our young people can start training for jobs that will meet the future and give them the ability to buy their own homes. Thank you.
Thank you. Perfect. Next up. City Manager.
On to consent. City Council consent is items A through L. Do you have any questions of staff for consent agenda items?
I see none.
City Council, do you want to pull any of the consent agenda items for further discussion?
I see none.
City Clerk, are there any cards on consent? Mayor, I'd like to read the titles for consent for the record.
Thank you.
Consent agenda item 8A, accept the state assistance for fentanyl eradication in Florida grant. Consent agenda item 8B, authorize the mayor to sign a letter of support to apply for the Florida Department of Environmental Protection Trails Go grant letter of support. Consent agenda item 8C, authorize the mayor to sign a letter of support to apply for the Florida Department of Environmental Protection Resiliency Florida Planning Grant letter of support. Consent agenda item 8D, approve the final rankings for fully insured plans for retiree Medicare Advantage plans and Part D prescription drug plans. Consent agenda item 8E, approve Community Aesthetics Feature Agreement Resolution number 12-2024. Consent agenda item 8F, approve the allocation of the American Rescue Plan Consent agenda item 8F, approve the allocation of the American Rescue Plan Consent agenda item 8F, approve the allocation of the American Rescue Plan Consent agenda item 8F, approve the allocation of the American Rescue Plan Consent agenda item 8F, approve the allocation of the American Rescue Plan. Consent agenda item 8F, approve the allocation of the American Rescue Plan.
Are on it right now if it stays zoned the same way. What's preventing him from doing commercial? No opinion was formed with that as well.
Vice Mayor?
Yes, I ran into Connie, I think, over the potatoes at Walmart. And she and I talked about it a couple of times, and I asked her a question, no, just general conversation, you know, but it was some nice potatoes at Walmart, I think we agree.
Member Cole, anything? No. I don't guess people are talking to me because I didn't get anything either. So, City Attorney?
Just a reminder where we are. At the last meeting, we had the applicant's presentation. we will continue that public comment. Of course, at the close of public comment, the applicant will have his opportunity for rebuttal before you deliberate.
Okay.
And Mayor, just
Yep,
before
go ahead.
just before we call the public comment cards, I believe the court reporter was not taking notes earlier, but I would just like to state on the record again my objection to any of the new cards being called that weren't previously turned in prior to the start of the meeting. At the I believe it was the July 23rd meeting, and that's on the basis of the city's Section 2-26, Rule 5B of your code, I believe.
Thank you. City Clerk, just for the record, how many cards were turned in after we allowed that?
From the July 23rd meeting, we actually had 27 cards left.
Right.
And then we received 6 additional cards tonight, but 2 of them have already spoke.
Okay, well then the 2 who already spoke, obviously, that's part of the deal. They can't speak, but that means
then
you have 4 new cards.
I have a procedural questions. I know that we were going to allow individuals to speak on behalf of individuals that could not be here
Correct.
tonight. But some of these people have already spoke at the last meeting. Is that okay?
They're speaking for someone else, so I don't have that problem, but I do want to defer. I mean, they're not really speaking, they're reading somebody else's words, but I don't want to violate anything, so, City Attorney.
I haven't encountered that. If they are reading, we did say that if they had something to read, someone to read it for them, they could do
Right.
that.
I'd like to stay with that. To me, it's not the same as speaking twice or reading for someone else. And that's a good procedural question. I appreciate that. Anything else we need to know before we go forward?
Staff is here to
Staff?
provide you a process again.
I have point of order.
Yeah.
Point of order. Attorney, we're giving you a copy of this. These are objections, and we're giving a copy to each one of you tonight. They will be provided to you by email. This is on the record. We're submitting objections based on the City Council failing to follow the adopted rules of procedure during the July 23rd public hearing for the Bristol Municipal Multifamily Development. The City of Titusville adopted Resolution 24-1997 to comport with case law and establish rules of procedure for quasi-judicial hearings, including ex parte communications, rules of evidence, the burden of proof, and the assurance of a fair opportunity to present evidence. Resolution 24-1997 has not been amended since its adoption, May 27, 1997. That's in Exhibit A of this package we just handed you. Combining the legislative and quasi-judicial proceedings is procedurally improper and unfairly limits opposition's opportunity to present evidence. Resolution 24-1997 distinguishes between the legislative and quasi-judicial actions and further defines the procedures for the City Council to follow in quasi-judicial proceedings. Combining the fact-finding and evidence-gathering portion of both the legislative and quasi-judicial proceedings is improper because these 2 distinct types of proceedings have different burdens of proof, rules of evidence, and right to cross-examine witnesses in the quasi-judicial only. During the hearing on July 23rd, those speaking in opposition and as substantially affected parties had to unfairly combine their objections to both the legislative and quasi-judicial proceedings into one combined 3-minute public presentation. Point of order. Bristol Attorney Cole Oliver cross-examined witnesses on their combined opposition testimony without a clear distinction between the legislative testimony and quasi-judicial testimony that he was cross-examining them on. Witnesses may also be cross-examined in quasi-judicial proceedings on relevant quasi-judicial evidence. Therefore, Mr. Oliver's witness cross-examination testimony should be stricken from the record. The combining of the evidence-gathering portion of the legislative and quasi-judicial process muddies the clear distinction between evidence testimony being presented and the respective rules of evidence and burden of proof. Point of order. Substantially affected parties' opportunity to present competent, substantial fact-based evidence unfairly truncated. The applicant is given unlimited time to present evidence and unlimited time for rebuttal after opposition testimony, an opportunity to use graphical and multimedia forms of presenting evidence via PowerPoint presentation. The unfairness of the process is evident when compared to the opposition, who gets 3 minutes to present policy and fact-based substantial and competent evidence. Making cohesive and effective presentation of fact is impaired by the opposition having to try to parse their fact-based objections into 3-minute bites and have been denied a fair and equal opportunity to present substantial and competent evidence via PowerPoint. See Exhibit A. We sent an email to the assistant city attorney. Actually, it went to the city manager as well, and we were denied. Combining the fact-finding portion of the proceedings unfairly impacts the opposition's ability to present evidence by even further compressing the time provided to present evidence for both legislative and quasi-judicial items in the same 3 minutes with their different burdens of proof and evidence. The City of Titusville's Land Development Regulations, Section 34-12C states, quote, "The burden of persuasion on the issues of whether the development will comply with the requirements of this chapter remains at all times on the applicant. The burden of persuasion on the issue of whether the application should be denied rests on the party or parties urging that the requested permit should be denied. By combining," end quote, unquote, "by combining the legislative and quasi-judicial proceedings and limiting time available to provide a persuasive fact-based argument, even when the opposition presents a unified objection or names a representative to speak on their behalf, creates an unfair advantage for the applicant." Point of order. Prejudice and ex parte communication. For quasi-judicial proceedings, ex parte communications are to be avoided outside of the public hearing and limited to inadvertent communications. Inadvertent. Deliberate communications such as meetings, in-person discussions over lunch, or telephone conversations, or planned meetings are deliberate. They're not inadvertent communications. Resolution 24-1997, Section 4.1, intent states, it is, quote, "It is the intention of the City Council for its boards to avoid contacts other than at hearings before the board, and that it is the desire and intent of the City Council to establish a process and procedure for disclosure of inadvertent ex parte communications." City Council members did not disclose all opinions or facts discussed during ex parte discussions with the applicants, landowner, or other representatives, including a lobbyist who is here tonight. Failure to disclose all opinions and facts discussed denied the affected parties the opportunity to know specifically what was discussed and have a reasonable opportunity to refute, rebut, or respond to the communication. While all the opposition's written ex parte communications were forwarded to the applicant by the City of Titusville, giving the applicant without the same disclosure with specific detail of all opinions and facts discussed in ex parte communications with the applicant, gives the applicant an unfair advantage over those in opposition to prepare rebuttal. Resolution 24-1997, Section 4.2A states, quote, "In the event a member of a board receives an ex parte communication outside of the hearing or proceedings before the board, said board member shall disclose and make a part of the record before final action is taken the identity of the person, group, or entities with whom the communication took place and the subject of the communication, including all opinions or facts discussed. Said disclosure shall be made before or during the public hearing at which a vote is to be taken, or said matter, and any persons having opinions contrary to those expressed in the ex parte communication shall be given a reasonable opportunity to refute, rebut, or respond to the communication," unquote. Point of order. City Council discloses at the July 23rd, 24 hearing regarding ex parte communication did not disclose of all opinions and facts discussed as required to remove the presumption of prejudice. Pursuant to Resolution 24-1997, Section 4.3, disclosures only remove the presumption of prejudice if complete and made in accordance with the process and procedures described in Section 4.2. Failure to disclose all opinions and facts discussed in ex parte communications. As required in Resolution 24-1997, 4.2, causes the disclosures to be insufficient to remove the presumption of prejudice arising from those ex parte communications with representatives of the applicant, landowner, or any other representative supporting their application, including lobbyists. Resolution 24-1997, 4.3 states, quote, in the event an ex parte communication should occur as described herein, and disclosure is made in accordance with the process and procedures described above, then in that event, any official action taken by the board in any quasi-judicial proceeding shall remove any presumption of prejudice arising from said ex parte communication where an ex parte communication has occurred, unquote. Point of order. The city council members disclosed there were ex parte communications with lobbyist Robin Fisher and Jason Steele in advance of the public hearing. Meeting with the lobbyist in support of the project pending before the city council is always presumed prejudicial. In quasi-judicial proceedings, the city council must be a neutral decision maker, relying on competent and substantial evidence presented during the public hearing. In Jennings v. Dade County, 587 South 2nd, 1337, Florida District Court Appeal, 1991, found ex parte communications are inherently improper and are anathema to quasi-judicial proceedings. Quasi-judicial officers should avoid all such contacts where they are identifiable. See Exhibit D. We provided that as Exhibit D. If further found behind-the-scenes lobbying for the purpose of influencing the outcome, a quasi-judicial proceeding violated the due process provisions of 1345, 1351, the United States and Florida Constitution. Prejudice is to be presumed from the mere fact that the City Council granted a private audience to a lobbyist whose purpose was to influence the council to vote a certain way in a quasi-judicial proceeding for reasons not necessarily addressed solely to the merits of the application before the council. Quote, lobbying is defined as any personal solicitation of a member of a legislative body during a session thereof by private interview or letter or message or other means and appliances not necessarily addressed solely to the judgment to favor or oppose or to vote for or against any bill, resolution, report, or claim pending or to be introduced by any person who is employed for consideration by a person or corporation interested in the passage or defeat of such bill, resolution, or report or claim for the purposes of procuring the passage or defeat thereof. Black's Law Dictionary, 1086, Rev. 4th edition, 1968. Point of order. Ex parte lobbying of an administrative body acting quasi-judicially denies the parties a fair, open, and impartial hearing. Suburban Medical Center versus Olaf Community Hospital. We'll give you a copy of this so you'll have it. 226 Kansas 320, 597 P 2D 654, 1979. Adherence to procedures which ensure fairness, quote, is essential not only to the legal validity of the administrative regulation, but also to the maintenance of public confidence in the value and soundness of this important governmental process. ID 597 P.2D at 662, citing 2 and 2D Administrative Law 351. Point of order. The quasi-judicial process for the Bristol hearing is prejudiced by City Council members receiving monetary donations from individuals and the lobbyist that are acting on behalf of the Bristol project while the matter is pending. Campaign contributions, public records show that several City Council members have received monetary campaign donations from Elizabeth Cole, who is the director of Wendover Farms, Inc., see Exhibit B. Elizabeth Oliver, Director, Wendover Farms, Inc., the landowner set to benefit from the Bristol development. Wendover, Inc. owns the 25-something acres that Bristol's trying to develop on. Mr. Cole Oliver is the attorney for Bristol, and it's his wife that is principal on Wendover, Inc., who has provided monetary donations to Miss Sarah Stokel. And Cole Oliver, the attorney representing the Bristol project before the City Council. Ms. Oliver does not live in the city of Titusville or even county district within which the city of Titusville city is located. Council members also received monetary campaign donations from Robin Fisher and Jason Steele, in particular, Ms. Stokel. In addition, we found out Ms. Stokel has a PAC. She's received $10,000 from Robin Fisher into that PAC. The same lobbyist council members disclosed the city council had ex parte communications. Jason Steele is also a seated county commissioner and served as an expert witness on real estate for Bristol at the July 23rd hearing. And Mr. Steele is here tonight, I believe, also. He's here. Point of order. During a quasi-judicial proceeding, the city council is acting in a judiciary capacity as a fair and neutral decision maker, relying only on the substantial competence evidence presented during the hearing, just as it would be disqualifying for a judge to accept money from one party in a legal action before them. The same is true for the city council. The same is true. In Jennings v. Dade County, the court found the constitutional compulsions which led to the establishment of rules regarding the disqualification of judges apply with equal force to every tribunal exercising judicial or quasi-judicial functions. 1 AM Jury 2D Administrative Law 64 at 860, 1962. In the city of Tallahassee versus the Florida Public Services Commission, 441 South 2D 620, Florida 1983. You have a copy of this, by the way, Mr. Broom. Standard used in disqualifying agency head, disqualification, now we're talking about that. Disqualification agency head is same standard used in disqualifying a judge. See also Rogers v. Friedman, 438 F Supplement 428, ED Text 1977. Rule as to disqualification of judges is same for administrative agencies as it is for courts. Citing K. Davis Administrative Law 12.04 at 250, 1972. Ritter v. Board of Commons at Adams County, 96, Win 2D 503. 637 P.2D 940, 1981. The same. Point of order. Speaker card presentation order, procedural error, and Robin Fisher. Reviewing the submitted speaker cards, a card was submitted for developer lobbyist Robin Fisher. However, he did not check whether he was speaking for, against, or neither. Didn't check. Mr. Fisher has lobbied for this project with the city council members and has lobbied for approval of the Bristol development in ex parte communications with the city council members. Mr. Fisher needs to either rescind his speaker card or he must be the first speaker tonight at the resumption of this meeting. The City Council is not following the procedures established in Resolution 24-1997 and resulting in an unfair process for those for substantially affected parties who participated in the legislative and quasi-judicial process. This was submitted as representatives from Wendover Farms, Sandra Klinger and Lindsay Grizzle, and the Wendover Farms Homeowners Association.
Thank you. All right, we're good. City Attorney, I'm not a real judge and I'm not a real lawyer, and I didn't stay in Holiday Inn last night, so I'm really going to need you to clarify these things. Where you at?
Well, with regard to your resolution on ex parte communications under 4.3, in the event an ex parte communication should occur as described herein and disclosure is made in accordance with the process and procedures described above, then in that event, any official action taken by the board in any quasi-judicial proceeding shall remove any presumption of prejudice arising from said ex parte communication where an ex parte communication has occurred. That's why at the meeting I ask you to disclose. And that's, we go through that process to remove, and the point of doing that process is to remove any presumption of prejudice. So that is why we do the ex parte presentations. With regard to the hearing, yes, there is one public hearing, but you do vote and we take each item separately. The land use is a legislative decision. You will vote on that as a legislative decision. And then the quasi-judicial will be based on that evidence presented and separately. So we do handle those separately, although they are presented in one hearing.
Okay, well, I'm going to ask this one too, because this is, the way we do this is the way it's been presented to me and the way I watched the previous mayor do it before me. And basically the way I'm guided to do it, and that is the applicant is unlimited in time, and I've understood there's a concern that the applicant, which has always had their chance for presentation, and then cards come up for 3 minutes. Explain that one, please.
That is correct. The applicant is supposed to be given a reasonable time. It's his burden. And he has to be given a reasonable time to present. And we do not have a specific limit in our procedures for that applicant, other than we know they have to be given a reasonable time. And then, of course, public comment is 3 minutes for each speaker under public comment.
Okay, so with that being said, clearly there is some, concerns expressed. What is your thought on where we're at right now? Just go forward with their
So
concerns?
where we are is more public comment, and of course, we will take the cards. We've opened that up for anyone who wants to speak. They'll have 3 minutes to speak on that item. At the close will be rebuttal, and then, of course, you will take those items separately, your legislative item and your quasi-judicial, and you will deal with those separately at the end of the public hearing.
Two clarifications
All
on
right,
the
real quick.
two clarifications on the point of order for as far as cards are concerned. We were told to combine our discussion within 3 minutes for both quasi-judicial and the legislative action. We believe that is unfair. We were not able to present, and also the attorney questioning the speakers did not identify whether it was quasi-judicial or legislative. He's not supposed to question on legislative, only on the quasi-judicial. So he did not clarify that or separate that in any way. And the Robin Fisher card, it should go first or not at all.
All right, city attorney can continue.
Well, that's true when it comes to cards. We take those for first, those against, but you cannot require someone to speak. If they have a card, they can certainly waive whether they want to speak or not. You cannot make someone speak.
If we're going to continue to go down the rules, in section 5.10A of the public comment cards, it doesn't say you take them in order of for, against, or neither. You take them in the order that they're signed up and turned in. So this idea that for some reason Mr. Fisher has to go first is just inventing a rule that's not in your process.
All right. All right. Hold up. We're not going to go back and forth with this group and that group.
Not consistent with what Mr. Broom read at the beginning of the hearing.
Say again?
That's not at all consistent with what Mr. Broom read at the beginning of the hearing, where he says, those in favor speak first, then those opposed. He presented the order of the public hearing. Did you not?
All right, Ms. Klinger, go ahead and sit down. Let me have him answer, and then we're going to go forward here. Go ahead.
Yes, those are the procedures that we read at the council meeting.
Tell me again?
Yes, those are the procedures we read at the council meeting. Certainly, someone could have a card neither. I'm not sure what a speaker card says, but again, if a speaker wants to speak, they will speak. If they don't want to speak, they're not required to speak.
And just for purposes of the record, I'm not sure where Mr. Broom was reading those rules from, but the resolution that they're referencing from 1997 specifically states in 5.10A that the public comment taking speakers in order they signed up and allow cross-examinations of the witnesses by applicant and staff representatives.
All right, so city attorney, at this point, we are going to move the cards that we had last meeting. And we'll start with those now. All right, let's go. Call the cards. How many? And that was about 30 cards now? All right, 30 cards.
Christine Boland.
Mayor, staff did want to talk to you about
Talk to us
process
first.
real
I'm
quick
sorry.
before we do the cards.
Let them speak, and then you go first.
Okay.
Thank you, ma'am. All right. Get back thing in order. Staff, you will present whatever you're going to present, and then we will start with Ms. Boland, and we'll go from there.
I just wanted to remind the council where we are and the procedure. I'll be real brief and just refer you to our findings and recommendations on page 252 and 253 of your packet. 252 and 253 of your packet, you'll see the findings and recommendations from staff in our report. As far as procedure, you'll make a decision as to the land use amendment. After that, then you'll make a decision, if the land use is approved, then you'll make a decision on the, well, approved or denied, you'll make a decision on the rezoning. The next step will be that rezoning, that's that quasi-judicial step. I just want you to be aware that if the land use amendment is not approved, then, and the existing commercial land use stays on the property, that the rezoning that we have presented to us with the conditions related to it, the rezoning, PD zoning, and the master plan, we would find that to be inconsistent with the current commercial land use. After that land use is decided on and the rezoning is decided on, if they are both approved, then on your next agenda item is the transmittal hearing only of the text amendment to the comprehensive plan, which is agenda item number 9B, to include or incorporate the maximum density into the comprehensive plan. If that is approved, then that will be sent to the state. We'll wait for their response. And if they do not have any objections, we will go forward with adoption hearings. And those hearings will mean an ordinance in order to amend the comprehensive plan with that maximum density. And that would probably happen maybe about 4 or 5 months after these hearings. With that, I'll try and answer any questions you have.
Any questions up here? All right, Ms. Boland, thank you.
Christine Boland, Armadillo Trail, Wendover Farms. Miss Sandy Klinger just gave you guys a hard copy of a supplemental to our objections.
This?
Yes, and she sent an email earlier today.
Yeah.
You have an email of it.
Didn't get there yet, but.
All right. The Wendover community submitted for the record a 35-page policy-based objection letter with exhibits digitally and as a hard copy from Sandra Klinger to the City Council at the July 23rd, 2024 public hearing. Speakers in opposition tonight and July 23rd are in support of the objection letter. Wendover Farms is a platted residential rural community with over 600 single-family homes on 1.5 acres each typically, and is adjacent to both the east and south side of the proposed Bristol project. Wendover Farms will be negatively affected by this high-density, multifamily, 304-unit plan development. Additional factual data and written addendums will be presented by speakers with testimony detailing the proposed Bristol development inconsistencies with the comp plan and the LDRs. The primary ingress and egress from Wendover Farms is Wendover Way, a 6-mile-long local roadway that winds through the neighborhood and was constructed as part of the platted subdivision. The city of Titusville has established procedures and criteria both the Planning and Zoning Commission and the City Council are to follow during consideration of both legislative and quasi-judicial applications and has been codified in the Land Development Regulations, Chapter 34, Article 2, and in Resolution 1997-24. Land Development Regulation, Chapter 34-21 states that it is the applicant's responsibility to demonstrate the proposed land use amendment and is fully consistent with elements of the comprehensive plan. Land Development Regulation, Chapter 34-40, the first criteria for consideration by the City Council is whether the applicant has provided evidence demonstrating the proposed land use, zoning change, and development is consistent with the adopted comprehensive plan and associated elements that are implemented through the adopted LDRs. LDR Chapter 33-8 establishes the review criteria for applications specific to a PD, which includes consistency with the comprehensive plan, internal compatibility, external compatibility with surrounding residential and conservation uses. The very first external compatibility review criteria, LDR Chapter 33-8 3A states, the proposed development shall not negatively impact the quality of life or any adjacent residential uses. Negative impacts can include a decrease in property values and any substantial increase in noise or traffic. Any traffic impacts shall be demonstrated with a traffic analysis, and the developer, in accordance with the comprehensive plan, shall mitigate the impacts. Thank
Good?
you.
Thank you.
Yeah, I had a little bit more, but you got a few.
Thank you. Okay, next.
Sandra Combs, speaking for Barbara Aubrey.
Perfect, thank you.
That'd be great if I could go there. Thank you. Michael. Hi, I'm Dr. Sandra Combs, and I live at 8038 Wendover Way, and I own 4 additional homes in the city of Titusville as well as a business. I would like to say that the existing commercial high-intensity land use is correct. As testified by your planning staff on 723, the existing commercial high-intensity land use is consistent with the comprehensive plan. The comp plan future land use element objective 1.9 states the city of Titusville shall provide for appropriate and adequate land for commercial land use through the designation of commercial high-intensity and commercial low-intensity land use designations on the future land use map. The proposed rezoning would continue to reduce the amount of commercial land within the city of Titusville. City council members have repeatedly publicly expressed concern over the continued loss of commercial and industrial land use within the city. The city staff testified on 723 that the city already has less than 20% combined commercial and industrial land available within the city. City staff also testified that maintaining adequate commercial and industrial land uses is important for the economic resilience and stability of the city. The proposed change of the future land use for this subject property is a legislative action by the City Council maintaining appropriate and adequate land for commercial or commercial use is a rational basis for denial of the proposed SSA 32022 from commercial high intensity to PUD. See the supplemental exhibit C6 for Florida court rulings on that. For the city to remain attractive to current and future residents for the city needs a good mix of commercial uses that provide residents needs for goods and services and employment opportunities. Even though telecommuting for some industries has increased, there is still a demand for restaurants, entertainment, retail, and service-oriented commercial businesses. On July 23rd, one of the developer's expert witnesses stated that in his opinion, other cities are using 10% commercial as a guide. As he stated, is for commercial. Don't be fooled or led astray. The Titusville 20% commercial plus industrial, not just commercial. So 20% commercial plus industrial requirement is correct. The existing regional commercial RC zoning is correct. According to the testimony of city staff and the written staff report, the existing regional commercial is correct. There have been no substantial changes in the areas surrounding the subject property since the RC zoning was adopted in 2008. Rezoning review criteria in the LDR section 3440A2 states, the existing zoning, if deemed consistent with the comprehensive plan, which it was, shall be presumed correct unless substantial change in the area has occurred since the original zoning. The applicant.
Are you close?
Yeah.
Thank you.
The proposed SSA 322 is associated rezoning in the master plan for the Bristol multifamily development are inconsistent with the city's comprehensive plan.
Thank you so much.
Thank you.
Next up.
Scott Roosh, 5875 Windover Way. Mayor, council members, evening.
Hey. Good evening.
So, the staff report states there is no significant impact to Windover Way. However, the Bristol study makes decisions and recommendations based on the omission of analysis of important significant road segments. Literally only half of the affected roads around the development were looked at. Look at the large exhibit. The road segments in yellow were the only ones analyzed. The red and omitted road segments, and obviously should have been included. The Bristol traffic study omits pertinent analysis of road segments that will certainly be used by Bristol residents. The segments include Windover Way, to and from Windover Trail, the blind, sharp 35-degree intersection. Windover Trail to and from State Road 405, the Walmart intersection. The road segments are not only omitted, the trips toward and away from these segments are marked as 0 trips. They are saying every single car leaving Bristol development will use the yellow highlighted road segment. Really? In addition, the traffic study omitted information on how Bristol residents will go west on State Road 450 toward Orlando. The current best route is pulling out on 50 East and then quickly cutting across 3 lanes of traffic to make a U-turn. Clear exhibit at Starbucks and Lowe's. Or you can cut across with a bit more time, dodge to the right-hand turns coming off 405 and make U-turn here, exit, exhibit at 50 and 405 and head back west toward Orlando. These are very dangerous traffic patterns that were analyzed but were certainly not used by Bristol residents. An increase to high-density residential traffic would have detrimental effects in this area. This degree of omission and inaccurate information screams deception. You rely on accurate information to make your decisions. You should immediately deny this traffic study and deny SSA 3-2022. Please vote to deny SSA 3-2022 and deny CPA 2-2024. And what else do I want to say?
And I believe you're about there.
Yeah, I think we're good. Yes.
All right, thank you.
Yeah.
Next one up, please.
Elizabeth Parker.
I'm sorry to hear that.
Elizabeth Parker.
Parker?
Back again. Elizabeth Parker, 3446 Trevina Circle. Excuse me. Windover Way, defined in the city's LDRs as a local roadway, is the primary ingress and egress for over 600 homes in the Windover Farms community. Windover Way is approximately 6 miles long and was constructed as a part of the platted subdivision. The applicant submitted a master plan. The traffic study, in the master plan, the traffic study states the proposed direct access for the proposed high-density multifamily PD development is onto Windover Way with a full access driveway. See Exhibit A1, Bristol Master Plan. This is not consistent with the City of Titusville LDR, Section 33-5A2. Access for development in a PD zoning is required to have direct access onto an arterial or collector roadway. See Exhibit A2, Titusville LDR, Section 33-5A2. Windover Way is classified as a local roadway. According to the City of Titusville Roadway Classification and Titusville LDR Development Review Procedures Manual, Section 9.4, see Exhibit A3, it is also classified as a local roadway in Brevard County. Windover Way's right-of-way is 80 feet wide and adjacent to the platted residential homes and is further reduced to 60 feet wide from the northeastern boundary of the Bristol property to State Road 50. The City of Titusville LDR Development Review Procedures Manual, Section 9.5, states the minimum right-of-way for the collector roadway shall be not less than 90 feet, and the minimum right-of-way for an arterial roadway shall be not less than 120 feet. See Exhibits A4, A5, and A6. The applicant has access onto State Road 50 through their existing 66-foot wide easement that connects to an existing and historically used access driveway on the eastbound lane of State Road 50, an arterial roadway. The applicant notified the city that they had an easement with access to State Road 50 that could be used if required. The Bristol development expert witness, in his testimony, said, in his opinion, FDOT would not re-permit the existing driveway access onto State Road 50 based on access management standards, but they have produced no correspondence from FDOT to support their opinion. Representatives of the Windover Farms community contacted FDOT permitting, safety, and planning staff, making it clear that this is not at all the case. Other speakers will address the correspondence with FDOT in more detail. I support the submitted objection document submitted by Sandra Klinger and Lindsay Grizzle and urge the City Council to deny SSA 3-2022, its associated rezoning and master plan. The City Council must not approve a master plan with direct access onto the driveway of Windover Way with a full access driveway. I've got to say, listening to their expert speak, he made the comment, well, it functions as a collector road. I could function as a school bus. However, if you put 60 children on my back, I'm not going to get them to school. It's just a point that has to be made. Thank you.
Thank you. Next up,
Jackie Leader.
say again.
Jackie Leader.
Hi, Jackie Leader, 7762 Windover Way. I forgot my own address. Windover Way. I'm here to talk about the Live Local Act. It says that we've been hearing that if this development doesn't get approved, then the application will be changed in order to obtain approval under the Live Local Act. And that's not likely to occur or get approved. I think it's been talked about before. You have Exhibit C3 that consists of a letter dated January 9, 2024, from City Staff Mandy Lamoth, Deputy Community Development Director, to Kimley Horn Developer. The letter contains staff review concerns and applicable policy constraints for the Bristol project if pursued under the local act. The letter states that the proposal is not in compliance in multiple areas. The first being parking space requirement, states that available parking must be calculated at 2.5 parking spots per dwelling unit to be composed of 2 spaces for dwelling unit and half a space of guest parking per dwelling unit. And that's COT TM Transportation Infrastructure, Section 9.16, Table 9.164. The proposed development is also not in compliance with the second requirement. Multifamily, medium dense residential, and regional commercial developments require the parcel to abut or be adjacent to an arterial or collector road. Windover Way is defined as identified as a local street. That's DRP Section 14.5.20.8, LDR Section 28.306, LDR Section 28-315, and COT Comprehensive Plan Policies 1.9.1, 1.14.5, and 1.14.6. So even under the Live Local Act, the access point must still be on an arterial or collector road. The proposal is not in compliance with the third requirement, which says the minimum paved width required for a local road is 26 feet. The minimum paved width required for collector road is 38 feet. The width of the paved portion of the ROW of Windover Way is only 22 feet. The fourth item on the list pertains to the mixed use of things that can't be done, pertains to the mixed use element as required in the Live Local Act. The mixed use element of the proposed development is missing per ordinance 48-3023. Whoops.
You good? Thank you.
Okay.
That'd be another step anyway. Next up,
Vicky Conklin.
I'm sorry, I didn't hear that.
Vicky Conklin.
Hi, Vicky Conklin.
Hey, I'm Vicki Conklin, 2920 Royal Oak Drive, Titusville, Florida. And I would just have a question, point of order. Is it policy for the applicant to position at the staff table for an entire city council meeting?
I can ask that question like I do, but I can tell you that when we've done this before, attorneys do. Go ahead.
There's not a rule on where an applicant can sit. We have to have them on the record. We do have a microphone there, but we do not have a policy on where the attorney will sit. That, counsel, if you want. But he has to be on the record.
It just seems the optics is not so good. Just a comment.
Thank you, Vicky.
Excuse me?
Go ahead.
So the Bristol Plan Development master plan identifies Windover Way, a local road, for both primary and secondary access, which is not in compliance with the City of Titusville land use development plans. And I would cite Chapter 34, Article 2, Division 1, Section 3440A, 1B, and Section 33.5A2. Also, Titusville Plan Development standards require PD zoning developments to be located with direct access on a collector or arterial road. And I would remind you, we're probably upcoming with several more projects coming towards the city that we really have to be careful as a city council to break the rules now, because then we're going to set precedent for future projects. And it's really not fair to the current residents or future residents if we don't follow the comprehensive plan. Windover Way is well established as a local road. City of Titusville has verified this. Calling it a collector road does not make it so. That sounds like something a politician would say. I like Liz's analogy about the school bus, and I think that's a better analogy than I can make. But as elected officials, I'm going to remind you again, you are stewards of the comprehensive plan. You took an oath to follow the comprehensive plan, and you have an obligation to follow it. Again, we have to protect the rights of the current and the future homeowners by being consistent with the plan. And Connie is indicating here what these land development regs are, and I know you have them in your documents as well. So I would close with saying, please vote to deny SSA 3 2022 and to deny CPA 2 2024. Thank you.
Thank you, Vicki.
We have Diane Froge, Frogge, for John Aubrey.
Diane Froge, speaking for John Aubrey. I live at 5825 Windover Way. The reality is that a regional commercial property on just this 20.4 acres would generate less trips into and impacting Windover Farms local road than this high-density residential project would generate. Remember, when it comes to the comp plan, you are evaluating protection of adjacent residential areas. Please consider the very difference between destination and origination points when it comes to trips impacting the surrounding areas. All commercial properties are destination points. All residential properties, such as homes or apartments, are origination points. And as Ms. Jolynn Nelson brought up about Target and Home Depot, that they have access points onto Windover Trail, that is true. But what is also true is that those are all destination locations, and destination locations are totally different than origination points. People come to Target, Home Depot destination points from outside Windover and leave and go back to their homes that are outside Windover. So they have no need to come down Windover Way or Windover Trail because they do not live there. If they exit into Windover Trail, they head to the light at State Road 405 at the Walmart, and they exit that area that way, never impacting Windover Trail or Windover Way. This would be the same if a commercial development was built on the proposed Bristol property. People would come from Highway 50, use a commercial resource at that location, at the destination point, and then exit back onto Highway 50 and return to their origination point. No need to come down Windover Way or Windover Trail. Only people whose origination point living in Windover would come into Windover. And furthermore, destination trips would occur throughout the day instead of the peak apartment origination trips occurring in the morning and after work, which would generate intense clustering, which is really against your comp plan. Now, let's compare. If the proposed number of apartments are built on this site with the access onto Windover Way, the apartments would be the origination location for the 304 residential units, which would be about 600 residents. All these residents and their cars would leave daily an estimated 1,400 times, going to destination points. Where do you think those destination points are likely to be? Walmart, Target, Wendy's, work, or the Space Center? They will return back to their origination point location by using the least restricted path down Wendover Trail, take the 35-degree hairpin turn onto Wendover Way, and then turn left into the apartment complex, massively impacting residents of Wendover Way and Wendover Trail.
Thank you. Next up.
Cynthia Taylor.
Cynthia Taylor, 8158 Wendover Way. Standards for PD City of Titusville LDR 33-5A2 states, a planned development shall be so located with respect to arterial streets, collector streets, and other transportation facilities as to provide direct access to such PD without creating traffic along local streets in residential areas or clusters outside the PD. See Exhibit A2. PD Review Criteria City of Titusville LDR 33-8A3A. External impact states the proposed development shall not negatively impact the quality of life for any adjacent residential uses. Negative impacts can include a decrease in property values and any substantial increase in noise or traffic. Any traffic impacts shall be demonstrated with a traffic analysis, and the developer, in accordance with the comprehensive plan, shall mitigate the impacts. The traffic impact study and Adams that the developer submitted failed to include critical roadway segments impacted from high frequency and predictable trip attractants such as Home Depot, Staples, Target, or the Space Center, where the shortest path is turning right out of the proposed full access driveway, sending traffic into Wendover Farms residential area via Wendover Way and Wendover Trail for the projected daily trips the Bristol high-density multifamily will create. Their focus was solely on assessing the level of service impacts and failed to include required analysis of traffic impacts on quality of life and property values of adjacent residential areas. The traffic analysis the developer submitted to the city assumed 0 of the 1,404 expected daily trips turning right out of Bristol Development's full access driveway onto Wendover Way to Wendover Trail. In addition, they only analyzed traffic during what they projected would be peak work travel times, AM and PM. This only accounts for 241 of the 1,404 predicted daily trips. Where is the analysis of the projected impacts from the vast majority of the remaining 1,163 trips and the shortest path to predictable destinations? The developer's own traffic engineer, Josh Black, stated that people are going to take the fastest route to where they want to go. Video public hearing testimony 7/23/24 at 2 hours 19 minutes. Yet the traffic study he prepared for Bristol omitted analysis of predictable high-frequency destinations like Home Depot, Target, and the Space Center. And the shortest path to get there was from Bristol's proposed driveway. See supplemental Exhibit C1. To demonstrate the shortest path to these high-frequency destinations, we have provided a simple Google Maps navigation to Home Depot, Target, and Space Center from the proposed Bristol driveway. For each of these popular destinations, the shortest path was turning right onto Wendover Way to Wendover Trail and into Wendover Farm subdivision. This reasonably puts a substantial percentage of the 1,404 daily projected trips into the Wendover Farm subdivision, negatively impacting the adjacent residential homes.
Thank you.
Thank you.
Next up.
Thomas Corinne.
Good evening.
Good evening.
Tom Curran, 3491 Foxwood Drive. All commercial properties are destination locations. All residential properties and apartments are origination points. There's a very distinct difference in traffic pattern for destination locations versus origination points. If a commercial site were to be built on this 20.4 acres of buildable property, this would be a destination point, and customers would be coming from the outside Wendover to the commercial location, use the services, and then leave the commercial location and go back to their homes. This follows the comp plan and does not negatively impact surrounding residential areas or create clustering along our local road. There is absolutely no doubt this developer is attempting to build a high-density multifamily development of 15 homes per acre under the guise of a PD and attempting to say it will have less impact than commercial property. They are using a defunct 2008 project traffic report to sway you to believe them. The 2008 16-year-old RC zoning site plan was for a large square footage retail and restaurant for the subject property, plus another approximately 7 acres of adjacent commercial property with development. This is the definition of comparing apples and donkeys. It should be no surprise that this old, larger project predicted more generated trips in a worst-case scenario that ignores many other permitted uses as possible under the existing commercial land use and RC zoning. Such permitted uses under the RC zoning include art studios, hair salons, coffee centers, auto sales, repairs, bicycle shops, boat sales, car sales, rentals, bakeries, delis, a bank, professional offices, and grocery stores. Under the RC zoning, most of the permitted principal uses are lower intensity and generate far fewer daily trips, which wouldn't result in incompatible height and visual blight. They would be more compatible with the adjacent residential area and would not further erode the percentage of land dedicated for commercial use in the city of Titusville. RC zoning would still have a direct access frontage on an arterial roadway, so they would not be creating increased traffic on Windover Way. See Exhibit C3, letter from the city staff. That 2008 project has long ago exceeded the site plan duration and is now defunct. One of the principals is now bankrupt. The Bristol project will negatively impact our quality of life, increase traffic, noise, privacy, safety, and decrease property value, and is in violations of the city's comprehensive plan. Please vote to deny SSA 3-2022 and its associated rezoning and master plan, and deny CPA 2-2024. Thank you.
Thank you, Tom. Next up.
Frank Rowe for Kevin Kohler.
Hey, buddy.
Frank Rowe, 8201 Windover Way. You guys got to be tired of seeing me. See Exhibit C2 FDOT and Exhibit A7 survey with 60 foot wide easement. The Bristol Master Plan shows direct access with a full access driveway onto Windover Way, a local road created in a plat for Windover's Farm subdivision, even though they have an easement for access onto State Road 50 and arterial roadway. The applicant is asking the City Council to approve SSA 3-2022, its associated rezoning and master plan in violation of their adopted comprehensive plan and LDR policies, such as FLU 1.3.1 and LDR Section 33.5A2, designed to protect single-family residential areas from encroachment by multifamily development and negative impacts to quality of life, such as traffic impacts from traffic. The applicant's expert witness, Josh Black, has claimed it is in his opinion, FDOT will not reissue a permit for the existing driveway access point due to proximity of off-ramp from I-95. But even after 2 years, Bristol developers have not provided any actual direct evidence or correspondence from FDOT corroborating that opinion. So we contacted the FDOT District 5 Office Traffic Engineering and Permitting Office engineers, FDOT Planning Department, and the FDOT Safety Engineer, Anthony Nose, and asked them directly. We have submitted a written summary of this correspondence to supporting Florida Administrative Code and FDOT supplied safety data, see Exhibit C2. The three most important facts learned were FDOT provides free pre-application reviews, see CH 14-96.003. 2, Bristol could have met with D5 FDOT traffic engineer Chad Lingerfelder for pre-application conceptual review of their site plan and traffic study. 3, FDOT District 5 Traffic Services Engineer Zachary, Zach, that's a nice last name, Zal Barentis, was asked directly how FDOT would evaluate a project like Bristol in a permitting review where the city has a LU/zoning requirement for direct access onto an arterial or collector roadway. If the use has changed and the FDOT access management setback from ramp could not be met. 2009, Chapter 14-97 FAC. He said FDOT would not deny an access permit because of access management setbacks if the property, land use, and zoning required arterial or collector access, and that they would work with the property owner. He further said, looking at this specific location,
Go ahead, finish that sentence.
there are a number of opinions FDOT would consider, such as revising the ramp yield, lane profile, and mitigate access management setback requirements.
Thank you.
Annie Bridges.
Hi, I'm Annie Bridges. I'm 6375 Windover Way. I'm going to take a look at Exhibit A4 and A5. Windover Way is classified as a local roadway according to the City of Titusville roadway classification in Titusville LDR Development Review Procedures Manual Section 9.4. See Exhibit A3, Titusville LDR roadway classification list. Windover's right-of-way width is 80 feet wide in proximity to the platted residential homes to accommodate wide swales to provide stormwater drainage. Windover Way was constructed as part of the subdivision plot specifically for ingress and egress for the Windover Farms community. Windover Farms is a large lot, 1 acre minimum, rural residential community located adjacent to the proposed development on the south and east sides. However, from the northeastern boundary of the Bristol property to State SR 50, Windover Way's right-of-way is reduced to 60 feet wide. See Exhibit A for Windover Farms Unit 6 plat map and Exhibit A5 parcel map. The City of Titusville LDR DRPM Section 9.5 states 2 significant facts. See Exhibit A6 Titusville LDR Section 9.5. First, the minimum right-of-way width for a collector roadway shall be no less than 90 feet. And second, the minimum right-of-way for an arterial roadway shall be no less than 120 feet. Highway 50 is an arterial road. The property has a 66-foot wide easement between the property and Highway 50. See Exhibit A7 survey and Exhibit A8. That was a notarized easement creating road right-of-way signed by both property owners in 1998. This is a viable easement already used by trucks entering onto Highway 50 through the 66-foot wide access was a truck stop, the gas station right along the boundary of this 66-foot easement, and a Greyhound bus stop right at the 66-foot wide entrance to Highway 50. It is used today. We in Windover believe in the land should remain commercial, but the 5.5 acres ground trough wetlands into OR zoning and conservation land use, like your policy requires, make all access onto Highway 50. Any commercial destination on that property will better serve its customers with access onto Highway 50, not Windover Way, which is a local road. Please vote no.
Thank you.
Carolyn Padfield for Ron Ball.
Carolyn Padfield replacing Ron Vall as Speaker. Look at Exhibit A2 and Exhibit A-4 that Sandra Klinger has provided to you, email and hard copy. Quote, Figure 1, standards for PD City of Titusville, DR 33-5, A2. 2, a planned development shall be so located with respect to arterial streets, collector streets, and other transportation facilities as to provide direct access to such PD without creating or generating traffic along local streets in residential areas or clusters outside the PD. Brad Parrish sent Bristol an email to the developers on July 22nd, 2022 that notified them that access would need to be located on an arterial or collector roadway, yet the developer's submitted plan ignored that observation and is proposing access onto Windover Way, a local road. Proposed access for this PD onto Windover Way is not consistent with Titusville LDR Section 33-5 A2, and review criteria Titusville LDR Chapter 34, Article 2, Division 1, Section 34-40A1B. Access for development in PD zoning is required to have direct access onto an arterial or collector roadway. On the Bristol Master Plan, both direct access and secondary access to the apartment development are proposed to be onto Windover Way, which is a local road. To note, the latest and greatest traffic addendum tries convincing the reader that travel down Windover Way to Windover Trail is not likely to happen without using any sort of actual model. They did a distracting time travel analysis with an arbitrary endpoint by the northbound I-95 ramp. Yes, it would take less time to travel to the northbound I-95 ramp using Highway 50 versus Windover to Windover Trail, but most people coming from their apartments are going to be traveling to destinations such as Walmart, Target, Home Depot, out to the Space Center, and the traffic study provided to you did not even address those destinations. Don't be fooled by the arbitrary endpoint, which supports the traffic won't go into our neighborhood and impact us. See Exhibit A-4. Windover Way was built as part of Windover Farms Unit 6 platted subdivision with Windover Farms single-family platted lots south and east of this property. Also seen in the Windover Farms Unit 6 plat provided to you as Exhibit A-4, shown Windover Way only 60 foot width up to Highway 50. Why would the city staff report to fail to identify that the Windover Way right-of-way actually shrinks down to 60 feet wide from the subject property to State Road 50, especially since the initial correspondence from the City Community Development Director on July 22, 2022, notified the applicant that Windover Way is not an arterial or collector road, Sections 9.3 and 9.4 of the city's Transportation Infrastructure Technical Manual, and that Windover Way is a local road and appears to have limited capacity to State Road 50. Please vote to deny SSA-3-2022 and deny CPA 2-2024. Thank you.
Glenda Rowe for Wayne Rogers.
Good evening. Glenda Rowe, 8201 Windover Way. See Exhibits A3, A5 through A12. Bristol PD Master Plan identifies Windover Way, a local road for both primary and secondary access, which is not in compliance with City of Titusville LDR Chapter 24, Article 2, Division 1, Section 34 through 40, A1B, and Section 33 to 33.5, A2. Also, Titusville planned development PD standards require PD zoning developments to be located with direct access on collateral or arterial road. The property has an established 66-foot wide easement across the adjacent 6.98 acre property to the north, providing direct access to SR 50 and arterial roadway. See Exhibit A3, Titusville LDR Roadway Classification List Exhibit A7, 2022 Boundary Survey depicting easement from Bristol property to SR 50 and Exhibit A8 Official Record of Easement. This easement can and should be used as access to Highway 50 for this property and not Windover Way. It is clear the property owner, who was even aware back in 1998 that it was important to maintain an access connection to SR 50. See Exhibit A8 from the clerk of court that is notarized, legal easement creating road right-of-way signed by both the landowner, Windover Inc., and George Dongle on January 27, 1998. It is important to note that the easement connecting to an established improved concrete driveway, see Exhibit A9, photos of existing driveway on SR 50 with an existing concrete and turn lane. This existing driveway was historically used as an access point for semi-trailers as a truck stop operated on the property where the easement is located. See Exhibit A10, historic aerials of property used as truck stop. The applicant notified the city that they had an easement with access to SR 50, that could be used if required. See Exhibit A-11, Bristol Concurrency Application with Exhibit A12. Yet, the existence of this easement is also inexplicably completely omitted from the staff report and background materials included for your review. Why did the staff neglect to tell you about this 66-foot wide easement to Highway 50? The new July 17th traffic addendum provides you with an opinion.
Thank you.
Carla Hinn.
Nice ending.
Carla Hinn.
Carla Hinn, address 7323 Wendover Way. A quote from the Titusville Comprehensive Plan, FLUE, Future Land Use Element, Objective 1.9. The city of Titusville shall provide the appropriate and adequate land for commercial land uses through the designation of commercial high density and commercial low intensity land use designations on the future land use map. Quote, the existing commercial high intensity on the subject property is intended to serve the city and regional commercial needs. The existing future land use is consistent with the city's comprehensive plan in that it encourages clustering of commercial use along the commercial segment of Cheney Highway and I-95. Pages 6, 8, 15, 16 of the staff report included in your agenda package state the existing commercial high-density land use and regional commercial zoning and consistent with the city's comprehensive plan and are correct. Titusville has made great strides in accommodating the house crisis. Now we must keep our commercially zoned properties for commercial development. I'm sorry, I'm having a hard time.
All right.
The wording in your staff report does not support the proposed request of changing the commercial land to residential. Page 5 in the staff report says, based on the most recent reports, the existing vacant residential land use designations have more than enough vested and available residential units to accommodate growth projections to 2030. 6 rental apartment developments are currently in site plan review and are under construction in the city. Has less than 20% of combined commercial and industrial land use categories. The amendment will continue to reduce the cumulative acreage in non-residential land use categories. Let's keep current clusters of commercial business together instead of creating clusters of cars where the PD city code clearly restricts it along local roads like Wendover Way. The majority of commercial business within the city of Titusville are 1-story high. Very few are even 2 stories high, which can be shielded from view from vegetation as setbacks. Traffic for commercial will produce very little traffic and noise during the hours adjacent residents are home from work. Commercial is correct and acceptable use for these properties. Thank you.
Thank you. Get that little girl water.
Dale Kohler.
Hi, Dale Kaler, 2865 Morning Dove Way in Wendover Farms. Rezoning review criteria requires that you look at the environmental impact of the proposed rezoning. This is requesting to remove existing conservation land and OR zoning and low development density on the wetlands and place 5.5 acres conservation easement, which is all wetlands, into a PD zone with zoning with 11.7 units per acre over the whole 25.9 acres, including the conservation easement. Obviously, placing a high development density zoning on conservation easement wetlands under PD zoning encourages its development over time. The protective zoning and land use would be gone, bulked into a planned development. The concern is that by applying a blanket high development density over the whole 25.9 acre parcel of land, the city has removed the low density protection of the conservation land use to backstop, and it's solely relying on St. Johns River Water Management District Conservation easement to protect the 5.5 acres of ground troughed wetlands from incompatible development activity. Excuse me. The adjacent property to the south and east are currently conservation, open space, and recreation, and its 5.5 acres that are all grounded troughed wetlands should remain protected as conservation or OR. The staff report indicates an existing wetland located in the southwest portion of the site is currently located within a conservation easement. Conservation areas will be owned and maintained by the owner based on best management practices. Well, what constitutes best management practices for a development when maintaining a conservation easement? If this portion of the property is rezoned from conservation/OR to PD, now it will remove the public's ability to be notified if there ever is a proposed change to the conservation portion of the property, and a simple administrative move prompted by the property owner to the St. Johns River Water Management District could result in mitigation. Wetland development is insensitized. A St. Johns River Water Management District conservation easement can be removed at any governing board meeting so long as some equivalent area is protected somewhere else, which does nothing to protect the functional value of the wetlands within the city. This is a particularly of heightened concern for this project. Mr. Cole Oliver, who has represented himself as the land use attorney for the developer Bristol Group LLC, is also appointed to the governing board member of the St. John River Water Management District. It seems like administrative approval for mitigating this portion of the wetlands would be an easy feat for Bristol if he's on their board. Please deny. Thank you.
Thank you.
Paul Leader.
Thank you. I guess it's on now?
Got it.
It's Paul Leader, 7762 Windover Way. The community is really coming together here because they care about Windover Farms. I'm going to go off script a little, and Connie is probably going to kill me on it, but I'm going to do it anyway. And also, I thought I was back in working with the IRS, the Internal Revenue Code, with all these sections. The community has done a really, really good job in doing their homework, bringing all the facts, sections, and everything to your attention. I'm just going to read one thing that relates to what Connie has here. Back in 2014, the owner of the property filled in about 20 acres of land, which of the 29 acres, or 25.9 acres, and that made him go have a mitigation ruling against him to have to put 5.5 in his conservation area by the flood district, St. Johns River Flood District. Because of that, the developer now is using the full 25.9 acres and not subtracting out the 5.5 acres that are mitigation. So that basically means that instead of 304 proposed apartments, it should be 65 less, number one. The number two is the beauty of Windover Farms. I'm going off script now. My teleprompter isn't working. But basically, Windover Farms is in a buffer zone, as I call it. When I look to buy a house in a community in Titusville, I looked for someplace that was kind of quiet and segmented out of the busy parts of a city or a town, with the 95 on the west side, 50 on the north side, Columbia Boulevard on the east and south side. You had an automatic buffer zone where I thought there wasn't going to be some 20-story or even 5-story condominiums or apartment houses put in. Well, then when you're talking about a 5-story condominium, apartment house, what you're doing there is you are changing the environment of the whole community because of it being a buffer zone. When I lived in Miami Lakes, I had the same buffer zone for 31 years, and it was great. Please vote no against this proposed change.
Thank you, Paul. Next up.
Zachary Flugenza. I probably pronounced that incorrectly. Zachary?
Thank you.
No Zachary?
Go ahead, next up.
Megan Moscosa, which is replacing Christine Kohler.
Good evening.
Hey, how are you?
Megan Moscoso, Demerit Drive. I just wanted to remind you, the P&Z, we did recommend denial of this 7-0, so I hope you take that into consideration. Also, the P&Z, we received an ethical training from the Assistant Attorney, Chelsea Farrell. And one of the things she told us in our training was that if we even drove past a property, that we needed to disclose that. So it's quite disappointing to know that certain members of council have taken money from lobbyists, attorneys, and expert witnesses. Member Stokel, I would ask that you recuse yourself from this vote for ethical reasons. But we're going to look at Exhibit A2, the Titusville Land Development Regulations in regard to plan developments. Section 33(6)(A4) states, maximum building height. Building heights must comply with any design standards or other plans or policies provided for in the area of the development, or must be compatible with the surrounding existing development patterns in the area. The Bristol site plan shows 6 apartment buildings that are 4 stories, 50 feet high, 2 to 3 stories higher than adjacent properties, and 1 full story taller than vegetation could possibly shield. There is not a precedent for this building height in Titusville east of I-95 until you reach the riverfront developments. The proposed development is not compatible with the surrounding existing developments. See page 3 of the staff report under surrounding property information. There are no developments to the south of the property. The area south of the property is conservation, open recreational, and includes a large pond. South of this pond is Wendover residents' homes on Foxwood Drive. To the east of the property are all single family, over 1 acre Wendover Farms properties established in the 1980s. Directly adjacent is a field off of Penrod Road used for model airplane flying. This field creates no visual or sound blockage from a proposed 4-story development. Directly adjacent to the west of the property is Interstate 95. Some hotel buildings to the west of 95 are 4 or more stories. However, there are no adjacent residential homes to these buildings. To the north and northwest of the property, there are no buildings more than 2 stories. These include 1-story abandoned gas station and field, 2 single-family Wendover homes, 1-story gas stations, and 2-story hotels. A 4-story high-density multifamily apartment complex with 304 units next to single-family homes is not a transition. It's abrupt and incongruent. It will negatively impact the quality of life for the adjacent single-family homes, including traffic, noise, privacy, and property values. Please deny SSA 3/2022 for this and many other reasons laid out before you. The community, as you can see, are opposed to the 4-story high apartment buildings being developed on the property. If the proposal was only 2 stories high and did not access a local Wendover way, but went out to Highway 50, that would be more plausible. Thank you.
Thank you. Next up.
Lindsay Grizzle.
Lindsay Grizzle, 2605 Gator Trail. I'm going to pick up on some speaker packets that weren't finished. The previous speaker talked about FDOT traffic study, and that their Bristol's engineer said that it was his opinion that FDOT would not let cars come out of that property onto that easement that's already established. So we contacted FDOT, and they said that not only part of it was that there was a safety concern for the cars coming off of I-95 onto that ramp. And I think he gave a number of 8 accidents per year, and that would be a challenge of putting their driveway onto 50 because of the increase of accidents that could cause. So we contacted them, we talked to them, and they said that it was not 8 accidents a year. It was, what was it? 2 accidents in the last 4 years that resulted in no injury. So minimal accidents coming off of 95, going on to 50 at that access point, or at that point. Okay, let's see, what else I have? Okay, so this is far fewer accidents, so 0.67 per year average than what the applicant's expert witness stated, an average of 8 accidents per year. This 95 and 50 area is not considered a traffic safety problem by FDOT. And if they had concerns about that, then they could have asked and presented you the information that FDOT told us we cannot go onto Highway 50, and they haven't done that. So there is a chance, and according to what we've asked FDOT, that they can go onto that on Highway 50 instead of putting their access roads on Titusville or onto Windover. Okay, I just wrote something while I was sitting there, so I'd like to read it. So in regards to the LLA, we've walked this together. You're willing to hear us and incorporate our recommendations from the research that our team was committed and conducted. And that was a month after month process that we worked together and supported the team and supported the city with our recommendations, which some of those were adopted. We are here and trusting that you will uphold your comp plan for the good of all of the comp plan for all the residents in Titusville. So this is a section of the comp plan that if you choose to violate it by voting for this access point and this development to go on to Windover, it's setting the precedent that all of the comp plans is not, should not be taken seriously.
I'll do it. Thank you so much.
Mayor, I have a quick question.
Yes, question.
Yeah. You might not know this, Lindsay, or somebody, but in regard to your comment about they may be able to exit onto 50, is that based on your conversation that with FDOT that they just haven't asked them yet, so it's potentially possible? So you're saying that we don't know because they haven't even asked to see if that's possible. We don't have any documentation on that.
We asked them in a situation where a land use and a zoning is required to go onto an arterial collector road.
Mm-hmm.
And the arterial collector road is at a point such as 95 and 50. Coming off of that ramp, there's a requirement for the number of feet before that driveway.
Okay.
Right? So that's what we said. In the event that that property cannot access Windover
Right.
and must access our arterial road, what happens then? And they said we cannot deny a property from accessing their collector road, and that they can work, that they would work with the applicants to come up with other further solutions as far as changing the yielding structure of 95. So they said there's numerous number of options that they could present and that they could have communicated with them about regarding the access point.
Okay. I'm sorry, I have a further question on that, and this might be for the applicant, is do you have access with where you own your property to get onto 50, or would you have to go through somebody else's property to get on it?
The access would be via an easement across our neighbor's property to the north. So we have a legal right to go across that property via the easement. But again, our experts and our correspondents that will present in rebuttal with FDOT state and show that they would likely deny that. access.
Okay. All right, thank you.
Thank you.
Can I add this?
Go ahead, Member Nelson.
And I was just going to add this because this is from Ms. Klinger's paperwork. And it basically says FDOT is unlikely to approve direct access to SR 50 if it is less than 100 feet from the tapered end of I-95. So, I mean, we've all driven that road. I mean, it's Titusville. We drive 95, we get off, whatever. And looking at the map, it looks really close. So I would sort of suspect they're not willing to do it.
All right, now next card.
Connie Milton.
You're passing that down, right? I'll say this, there's extra rows now on this one, so I'd like you to look at the extra rows. The expert witness, oh,
Don't start, yeah.
yeah, pass it on
We'll
down.
make it down.
Thank you.
Okay, so
But I can't get it apart. There we go.
Connie Milton, Wendover Farms.
Okay, here we go. Clock.
There's extra rows on here. The expert witness, one of the, Mr. Steele, in fact, I think, had said it was 750,000 ad valorem taxes. Wow, that was supposed to be, wow, wonderful, right? Well, the reality is, in comparing all these other apartment buildings within Titusville and the single-family homes within Titusville, the reality is not 750,000 ad valorem. Maximum, if you compare to this Solar Mare, the maximum would be 630. But Solar Mare's got 9 buildings, not just 6. Okay, it's 20 acres, but it's got 3 more buildings. So reality is it's more going to be like an ad valorem of 400,000. But Titusville, if you look at the comparison of all these, Titusville would get maybe 150,000 of that ad valorem. You would get about 28,000 of non-ad valorem out of this property. So 750 ain't it. The other thing is the FDOT. When we spoke to FDOT, they indicated that they would not insist on the 100 feet. They could reconfigure that exit ramp, put a light there, and they would work with the landowner to get onto 50, because your requirement says they have to use a collector road or arterial road for a development like that. So FDOT would not deny access. You've got an existing access right there. It's a gas station. They do it all day long, right there. So that 66-foot wide easement, if you look at that survey that we've been showing you, the 66-foot wide easement right here is right next to that gas station. In fact, can use part of that the concrete that's there for the bus stop and the truck stop. The concrete's right there. So it's been used for years. So there is no, and the FDOT said that they will work with the owner that has to have access on the 50. They would not deny them access. So that's not an issue. Do you, City Council, ever research what a so-called expert witness says? Or do you just assume, because they are, quote, expert witness, that they will tell the truth or that they never make errors in judgment? We looked into this statement, the 750,000. That's the results. Those are actual on-the-ground results that you have in your Brevard County Property Appraisers page today. You can look it up yourself. I've got a bigger spreadsheet that tells you who the owner is. And by the way, all these apartment buildings are owned from people outside of the state. Now, I think one's in West Palm Beach, but it's all not local people. By looking at Brevard County Property Appraisers, the Brevard County Tax Collector's webpage, and actual data from each location.
Thank you, Connie.
Sorry, quick, this will be a conversation with FDOT. Was that just via telephone, or do you have anything that you could provide us that shows an email what they
We
said?
got telephone conversation and emails. Yes.
You do have emails? Do you?
In your package, that supplemental package that we gave you.
The second one?
Yeah, which exhibit is it
second one.
in there? Just so we can look at it.
This one, right?
No, I don't need that one.
And then also his response, and then the first one is his safety analysis
T, they were looking at the actual exit ramp. They were looking at the actual data, exactly where we're talking about. It wasn't theory, it was actual, the location.
Okay, and I see the one email here. Okay, thank you.
Thank you. Next up.
Linda Crawford for Paul Malsbury.